Hello, this is Alexander Cross, criminal attorney here in the San Francisco Bay Area. Be sure to subscribe to our channel if you'd like to learn more about criminal law offices of Cross and Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with theft and DUI. Let's see. It says right here, I was arrested after having taken some items from a store and I had driven there drunk. Well, this is interesting, but first of all, if you go into a store and you steal a few items, as long as the items that you take are valued at less than $950, this should be a misdemeanor under Penal Code Section 484, which carries up to 6 months in the county jail. Now, if you take more than $950 worth of things, well, then now we're talking about a grand theft, which would be a violation of Penal Code Section 487. That carries up to 3 years in state prison. Now, regarding the DUI, you could potentially get a DUI if you're there at the store drunk. For instance, let's say you get detained by loss prevention, and then let's say hypothetically the police show up in 5 minutes and cameras show you coming into the store only 20 minutes earlier, and you drove there and there's nothing indicating that you had been drinking. There's no alcohol inside the car, which meant that you had to have been drinking before entering the building. Well, let's say they take your blood and you're at 3 times the legal limit. Well, there's no way that you could have been under .08 just 25-30 minutes prior during the time that you would have been driving the vehicle. So in a situation like that, the authorities could relate your blood back in a sense and charge you with a DUI just simply by realizing there's no way you could have been under the .08 if you had not been drinking, and the police got there within 5 minutes after your detainment, and you'd only been at the store for about 20-25 minutes. Yeah, they could put together a case for a DUI there. But you have to understand that the other thing that this brings to my mind is the concept of voluntary intoxication. Remember, voluntary intoxication is not a defense to a crime. You can't say, oh, well, yeah, I stole a bunch of stuff from the store, but I didn't really realize what I was doing because I was drunk. Well, look, yeah, that could be used to maybe mitigate the punishment down the line, but it's not a basis to defend yourself. Now, if somebody were to kidnap you and drug you, okay, you have a story right there. You have the defense right there. But if you purposefully went out, got yourself drunk, went to a store, and you did something bad, well, no, that is not going to be a defense. Remember, voluntary intoxication is not a defense to a crime. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime here and you need representation in court, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we will be talking about somebody who got arrested, but he only had a pellet gun. See you on our next video.